Second reading of this bill.
I call Jackie Dean.
Mr Speaker, the purpose of this bill is to improve the jury's administration and also maintain its integrity. But most importantly, and I think this is important and I think it is worthy of mention, is to help maintain jurors' privacy, their safety and, most importantly, their sense of safety and also their security. Through this bill, we are ensuring that victims are heard, they get the support they need, and they are not brutalised again when defendants are tried. And I don't think we should underestimate the impact on a juror or the juror whose address and particulars were revealed to a defendant. It's something which must be guarded against, and this bill, the Jury Service and Protection of Particulars of Jury List Information Amendment Bill, seeks to do just that. And while I acknowledge that one cannot completely hide juries' particulars, of course is the electoral roll, of course is the phone book, but I believe we should be doing everything we can to make jury service a safe activity for those New Zealanders who are called upon to do that. And just on that matter, the provision in the bill which gives registrars the power to grant a person permanent excusal from serving on a jury, that is on the grounds of disability or chronic health problems or indeed age, was, I suspect, misinterpreted by several of the submitters to this bill who labelled it as ageist. I don't believe it was ageist. I believe it provided a little bit of a lack of or a getting rid of some form filling for those over 65 who, for whatever reason, decided that they did not wish any longer to serve on a jury should they be called, and this provision in this bill provides that they don't have to make application each and every time. The view of the Select Committee was that, in fact, this was a good thing, rather than making any comment or any ageist inflection on people. The Select Committee regarded it as a good provision, one that would make life easier for those people who, for whatever reason, decided they did not wish to serve any further on juries. And so the main provision of this bill is to remove the addresses of potential jurors from jury lists. But what it does do is allow the prosecution, the defence lawyer, or the court-appointed advisor to dependents representing themselves to have automatic access to all that address information on request. But it does prevent the accused from ever seeing the potential jurors' addresses by prohibiting the defence lawyer or the court-appointed advisor from showing the addresses to the accused. Now, it extends section 14A(6) of the Juries Act, which makes it clear that misconduct in relation to jury lists may be treated as contempt of court, and to include the act of showing the accused or any other person's jurors' addresses will now be regarded as contempt of court. Some further changes in this bill, as it is returned from the Select Committee, is to prevent certain people sentenced to home detention from serving on a jury. So this closes a loophole in the Sentencing Amendment Act of 2007, which created home detention as a sentence in its own right, but failed to amend the Juries Act. And this meant that those who had served or were serving a home detention could still sit on a jury panel, and people convicted of a custodial sentence of more than 3 years, they will be barred for life from sitting on a jury. Further changes to the bill ensures that offenders who are serving a sentence of less than 3 months home detention to be excused from jury service are allowed to defer their service until they have completed their sentence. Gives registrars the power to grant a person permanent excusal. I've already mentioned this. And so currently a jury list must contain the name, occupation, date of birth and full address of potential jurors. This very important point, this sticking point for jurors now has been corrected. I commend the bill to the House.
Speaker.
Call Ian Lees-Galloway.
Thank you very much, Mr Speaker. Well,